Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to our Curious Amalgam. I'm Alicia Downey, and the title of today's episode is Can Demanding Price Parity Harm Competition? The MFN Paradox. What is MFN? It stands for Most Favored Nations, and in the context of buying and selling of products, it refers to a situation, a contractual agreement usually, in which a buyer and a seller agree that the buyer will always receive the seller's best price. That is, no other customer will receive a better price than the buyer. What's the angle on MFNs in this episode? Well, it has to do with platform MFNs, which we'll hear about in more detail. But first, I want to welcome my co-host, Barry Nigro. Hi, Barry.
Thanks, Alicia.
Barry, would you like to introduce our guest?
Of course. We are joined by Tasneem Chipty. Tasneem is an expert in antitrust economics. She's taught economics at several universities, been a managing partner at some of the large competition consultancies, and most recently was the global head of the economics practice at a large management consulting firm. Tasneem now works as an independent consultant through her firm, Chipty Economics. Tasneem is also a vice chair of the Antitrust Law section's Pricing Conduct Committee. Tasneem, welcome to our Curious Amalgam.
Thank you, Barry and Alicia. It's my pleasure to be here.
Let's get started. So we are talking about MFNs and pricing parity, as the title indicated. Are MFNs limited to pricing, or can they cover other terms and conditions? I mean, how many different kinds of MFNs are there?
Oh, in principle, an MFN can be about any term or condition. There can be as many as there is creativity in the business marketplace. An MFN is simply a guarantee that a buyer receives the same specific benefit as another buyer, whatever that benefit might be. So, for example, a buyer might ask a seller for as fast a shipment as provided to any other buyer. Of course, the most common MFN in practice is probably a price MFN.
Now, relative to antitrust and competition law, are MFNs or price parity clauses generally viewed as pro-competitive?
MFNs can certainly be pro-competitive, and I think historically they have been viewed as generally pro-competitive. But there can be many circumstances that one would have to consider to ultimately evaluate whether an MFN is pro-competitive. Let me give you just a couple of examples where MFNs might be pro-competitive. So, for example, MFNs received by small buyers. If a small buyer is guaranteed the best price, it might be able to enter and compete against a large buyer. That could be pro-competitive. Think about MFNs in exchange for a significant investment. Imagine a buyer that would have to make a significant investment, say, in distribution technology in order to spread and sell the seller's product. If after the investment is made, a seller then gives the buyer's competitor a better price, that would make the buyer's initial investment unprofitable. Right? In that type of circumstance, the MFN might give the buyer the assurance it would need to make the investment in the first instance. So in economics jargon, we would say that the MFN and that type of situation would protect the buyer from potential expropriation of an efficient investment that could ultimately benefit competition.
Now, Tasneem, there really have been no cases in which an MFN clause standing alone has been found to violate at least U.S. antitrust law that I'm aware of. But there have been cases in which MFNs have been alleged as a means of facilitating horizontal agreements among competitors. The most famous case that I know involved ebooks. Can you talk about what made the MFNs in that case problematic?
Well, ultimately, in that case, the question was whether the form of the MFN, which was the price guarantee given to the collection of the large booksellers, kept the booksellers from competing on price in ways that they otherwise might have. In that particular case, the MFNs were also thought to be a collusive or facilitating device that had the effect of elevating price.
So, as I recall, it was a situation in which each of the publishers had been corralled into agreeing to MFNs with Apple. Is that right?
That's correct.
Okay, so the issue there was that the use of these MFN provisions kind of tied them all together and resulted in what was essentially a horizontal price fixing arrangement. And so that was the basis of that challenge. The MFNs alone weren't necessarily the problem.
That's exactly correct. In fact, the ability of an MFN to facilitate and coordinate competitors to simultaneously keep prices elevated is thought to be the most classic mechanism through which an MFN can be anti-competitive.
Tasneem, you wrote an article titled Platform MFNs Can Asking for the Lowest Price Discourage Competition, which appears in the Pricing Conduct Committee's January 2024 newsletter. A link for the article is in the program notes on the episode page. What's a platform MFN, and why are platform MFNs a competition concern?
A platform MFN requires that sellers not offer their products or services at lower prices on other platforms. So platform MFN involves platforms. This type of clause can guarantee a platform that no other platform will charge a lower final price. Right? And there are different types of platform MFNs, wide and narrow, and that can be of consequence in evaluating its effects. A wide platform MFN involves all channels of sales, including sales through other platforms. Narrow platform MFNs apply to direct channels of sales, like the seller's own website.
Pre-internet, MFNs sort of raise questions with respect to pricing or other terms and conditions by large retailers and their ability to get or request the lowest prices, as you say. Now with the internet, we have platforms. Did the platforms increase the potential harm from MFNs, decrease the potential harm? I mean, does it matter that it's a platform? And if so, what difference does it make?
Well, in some ways it doesn't make a difference, and in other ways it does. Let me tell you how it does make a difference, okay? The important thing about platforms is at least many platforms require scale to be successful. And the minute you have that aspect of the business as being important, what we will probably encounter are large platforms. And so when we think about whether and why an MFN, a platform MFN in particular, might be anti-competitive, you have to start with the question of whether the firm that's asking for the MFN or who's getting the benefit of the MFN has market power. So the concern is that a platform with market power that demands a wide MFN essentially ensures that no other platform could credibly compete with it. And that would be okay. That is, demanding an MFN would be okay if it were the outcome of the competitive process. But here, the concern is that the first platform got large and then secured the advantage of sort of the price advantage, not because of something valuable it did in that instance, but because of the contract, which it could not have secured but for its scale. In these types of circumstances, competing platforms would have a hard time winning business, even if they innovated. And that's why we think platform MFNs are in some ways more risky, because they start with circumstances where the incumbent firm has market power because it has scale.
And there's an example of the government's interest in this situation ongoing right now, as your article explains. The FTC's case against Amazon includes allegations about its use of MFN clauses that I think are consistent with your description of wide restrictions. Is that right? In looking at that complaint, does it suggest that the government is opposed to the use of MFNs by platforms generally, or is it a situation unique to Amazon?
So I could only speak from the language of the complaint. I'm not working on the case itself. My reading of the complaint is that this isn't a blanket prohibition on the use of platform MFNs or wide platform MFNs in particular. The complaint appears to be particularly concerned by the use of these wide MFNs by a firm with substantial market power. And there appears to be, from the descriptions in the complaint, specific mechanisms and pathways through which this firm's use of a wide MFN has already interfered with competition. So I think it's a specific challenge, not a general challenge. At least that's how I read the complaint.
So MFNs, to my ear, sound like they're a good thing, although there's some concerns when they're sought by large players in the market. What should a selling platform bear in mind if they want to deploy MFNs without triggering a government investigation?
Well, I think just for starters, it would be relatively safe to use an MFN in an unconcentrated market with many buyers or sellers. So sellers that want to offer their buyers MFNs or buyers that seek MFNs should think about whether there are good substitutes available for the input in question, should think about what the rationale is for that price guarantee. So, for example, I started by telling you that MFNs can be pro-competitive if there is a investment enhancing aspect to the use of the MFN. So, firms that want to engage in especially wide platform MFNs should think hard about what are the activities that the assurance will allow them to engage in that they might not have otherwise, and how might that benefit consumers. And ideally, whatever the set of rationales are for sort of the use of those wide platform MFNs, it would be important to have a ordinary course understanding and rationale developed during the course of the business as opposed to after the litigation is filed.
So those sound like some of the same types of questions you might ask in connection with an exclusive dealing arrangement. What pro-competitive purposes are being furthered by the arrangement? Let me ask the question in a slightly different way. If the MFN is narrowly tailored, let's say it's just focused on seeking the lowest price, aren't there other ways that competitors can compete, let's say through innovation or by offering other benefits to customers beyond just the lowest price?
Yes, certainly firms have lots of ways to compete for customer business, but this can be a problem, let me say it that way, if in some circumstances, certain of those sort of additional ways to compete, say by offering a snazzier, user interface, or by offering, graphics or services, say reviews and ratings that are informative to consumers before they make the purchase decision, offering those types of additional aspects of a product that could allow the platform to compete for sales might not even be possible in a circumstance where the platform doesn't make significant investments up front. And so it's those investments up front that might never take place if the platform thinks that at the end of the day, the investments would not materialize in returns because of the free rider problem, the opportunism that I talked about earlier, where then the seller then sells its product to other buyers at lower prices. So you could have the first platform having invested, but still not recouping enough sales because of the free rider problem.
I think your article notes that this is a situation then in which you might be dissuading potential entrants from competing at all.
That's exactly right, Alicia. And that, I think, especially in the FTC's complaint against Amazon, is one of the most fundamental sort of concerns they have. Not just about entry, but expansion of a nascent or new platform that currently is at a very small scale. And if you play it out, why would you enter in the first instance if you thought after all of that you couldn't grow to a scale you would need to survive?
And I think another red flag for cases that have involved MFNs seems to be the situation in which at the time of the contract is formed, there's a huge imbalance in leverage, both in the context of regular just buying and selling MFNs and in the platform MFNs. That would also be something to watch out for. Would you say that's correct?
That's exactly correct. In fact, what you just described is sort of a circumstance where you have a small seller and a large buyer. So that's the asymmetry. And in the case of the FTC's complaint against Amazon, that's exactly the concern, that in that circumstance, the buyer demanded MFN. It would not have been possible but for the leverage or market power of the buyer.
So we've been talking about MFNs from the perspective of a contractual provision where the seller has an obligation to sell a product at the lowest price. What if we got rid of the contractual provision and the buyer of the product just asked for the lowest available price at the moment? Does that mitigate any of the concerns that we've been talking about?
So you mean they're just asking with no teeth, and the seller can choose whether or not to go along with it?
Correct. Because what I'm getting at is the rule or the principle that flows from this that large buyers aren't entitled to or simply can't request the lowest price.
I don't think any buyer should be precluded from requesting the lowest price. I think all buyers want to pay the lowest price. The question is how much of that request is from an exercise of market power that is a demand without conferring some value in return versus a sort of legitimate, maybe legitimate's not the right word. It's the natural outcome of a competitive process that the seller wants to give the buyer the lowest price because some aspect of the buyer's distribution network enhances overall sales for the seller. In that circumstance, the large buyer would get the lowest price without a contractual clause that would necessarily guarantee it. I don't think this is about whether a large buyer should or should not get the lowest price. It's about the circumstances that gave rise to that outcome and whether those circumstances were ultimately pro-competitive or really represent the exercise of market power without conferring some benefit to competition at large.
Well, that's a great way of summing it up. Thank you very much, Tasneem, and thank you, Barry, for an interesting conversation about MFNs. But before we let you go, Tasneem, we're going to ask you a couple of questions to let our audience get to know you a little bit better as a person. So first, can you tell us something interesting about yourself that is outside of your professional life?
Sure. I knew you would ask me this question, and so I thought I would share. I like to push myself to my physical extremes. So I thought I'd give you some examples. My favorite yoga is Bikram yoga, which is a 90-minute practice at 105 degrees. I do this a couple of times a week. And once a year, I bike from Sandwich to P-Town, which is about a 90-mile ride that takes you from the Lower Cape to the outermost extreme. Of course, once I get there, I have a very cold beverage.
Okay, well, we'll look for you as a contestant on the American Ninja Warrior series next.
You should try the Seagull Sentry down on the Eastern Shore. It's a 100-mile ride, and it's been done by a lot of competition lawyers in the past, so you might want to look into that. It's fun. Okay. So our next question is a little game that we like to play called Our Curious Hat.
And now it's time for the Curious Hat!
So, Tasneem, the rules are pretty simple. Alicia is going to pull a random question out of a virtual hat, and you will give us your best answer.
Okay, here I go. I'm rustling inside the imaginary hat. Here is your surprise question. If you were given $50,000 on the condition that you had to spend it all in 1 hour, what would you spend it on?
Goodness, $50,000 in 1 hour. All on the same thing? Anything I want?
It's you can answer it however you want.
I guess I'd get online as quickly as I could, and I would book a series of trips to cities I've never been to.
All right, so experiential spending. Well, thank you very much, Tasneem. This has been a great show, and thank you, Barry. Everybody, tune in to the next Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.